30 minutes for appellee. May enter your parents and proceed.
Thank you, Chief Justice. My name is Amber Feyerberg on behalf of the defendant. Good morning, Chief Justice, justices of the court, counsel. As I said, my name is Amber Feyerberg. I represent Alexee Trevizo, the defendant appellee. The legal issues here, although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations. Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the detriment of New Mexico patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report, there is no privilege, there is no Miranda rights, there are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda, the argument as I understand it from the state, isn't related to the duty to report. I think the duty to report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore, there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. But let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice Vigil, there are basically two universes we can be in. We can be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies. The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer, Senior Justice's question, mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't, and the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier, and that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexee.
That really seems related to interrogation. We're talking about custody. The question is, was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody. He's been arrested already, and he's taken for medical treatment in the emergency room. And then we have La Couture, where it's not they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely. Ibarra says, and I don't have the pin site on me, but Ibarra says, I do have it highlighted. Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in Law&Crime, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was
Correct.
no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is so important, Your Honor, because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you just
Yeah.
in answering that, can you, because the state did, can you, in discussing custody, talk about the 2 minutes prior to the officer telling her that she was detained versus what happened after? Because the state seems to be breaking it up like that. And you might not agree. I'm just wondering if you can address that. Because in my mind, that could possibly be an issue. The 3 minutes prior to them telling her she was detained.
Correct. Yeah. So the questioning started 3 minutes prior to them confirming that she was detained. To my mind, Your Honor, the reason that doesn't bear on this case in the way that the state wants it to is because that was a confirmation sheet. And he said earlier, we heard counsel say, this isn't a whodunit. This isn't who had the baby in the bathroom. So there's nothing that was stated there that would have taken police from a place. And that's where that pre-confrontation comes in with the nurse, where he says, she went in there to harm her pregnancy. She's lied the whole time she's here. She's gonna lie to you, and she killed the kid. So they're operating under, we're in a homicide investigation now. She's our only suspect.
And I think the through line of what you're saying is Miranda doesn't require confirmation by the police that you're being detained. I mean, our case law all over the place handles cases where there is no confirmation.
Absolutely. And the one thing that we haven't yet addressed, Justice Bacon, is the main difference between those cases on which the state relies and this one is the placement of police, where they're either just in the emergency department, they happen to overhear, or they're standing back, and there's this independent conversation. What we have not seen in any of those cases that makes this one markedly different is that these officers were physically blocking the door. We heard counsel talk a lot about that video. In that video, we see Alexee Trevizo on the bed, hemorrhaging in a hospital gown. Those are the circumstantial ideas, right, that we talked about earlier, that your honors talked about earlier in terms of circumstantial custody, that she's not free to leave. But that's not what puts her in custody for Miranda purposes. I mean, that's part of the coercive environment that they're exploiting, that they're taking advantage of here. But the reason she's in custody is because she has 4 authority figures acting in concert, only one of whom she's ever seen before. That's the doctor, the charge nurse. And as if you've all seen the video, he's a large man who aligned himself very strongly with police. These 3 men walk into the room and they're physically blocking the door. The operative question for the court is, would a reasonable 19-year-old high school girl in that situation feel free to leave? And the answer is no, even if she wasn't hemorrhaging, even if she wasn't hooked up to an IV, even if she hadn't just experienced the first vaginal exam of her entire life and the precipitous labor and delivery of what the defense posits was a stillborn in the bathroom. Those all contextualize it. Yes, Your Honor.
I don't mean to interrupt you, but I really do want to talk about the privilege. We have not had an opportunity with the state to really talk about the privilege either, but I need you to identify something pretty specific to me because I don't know the answer to the question.
Absolutely.
What, to your client's mind, did the doctor say? What's the actual violation of the privilege? What are the words spoken by the doctor that you assert are a violation of the privilege?
I'm not sure that that's the way, Your Honor, that I conceptualize the privilege. The privilege is a rule created by this court as a rule of evidence. So the question is, so the doctor can invoke Alexee's privilege for her and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines and did not. But in terms of waiving the privilege, only Alexee can do that. And so this is a,
Before we waive, get to, it's a privilege.
Yeah, I mean, why is this,
Why is there a privilege?
what is the privilege being asserted here? I mean, I know that it's a physician patient, but what is happening? What have you identified as triggering the violation of the privilege?
well, the violation, there's actually two different
Okay,
violations.
and that's what I want to try and
Yeah,
understand.
there's, and you can see this from the court order because we've got the district court made an order, one on the statements made directly responsive to the collective confrontation in the room, and also,
But that's what I want to try and get to, because if the privilege you're asserting that's been broken is the statement of, we found a baby in the trash, that's not a privileged statement, because it's not about Ms. Trevizo's healthcare. It's just a statement.
I'm not sure I would agree with Your Honor.
Well, let me
Okay.
finish. So to me, that is not a violation of privilege. The remainder, we need to transport, bleeding out all of that information, I might agree with you as a violation of the privilege, but in this context, given the suppression here, I don't think anybody cares, because that comes after the inculpatory statements by Ms. Trevizo. And so if that's a violation of the privilege, sure, but it's not what is really at issue here.
What's really at issue here, Your Honor, are Alexee Trevizo's statements. It's not the doctor making a statement. The doctor and the nurse both did violate their duty of confidentiality several times by telling officers, I think you said earlier, Justice Bacon, I'm not sure they should have, but to get to the actual statement that is, there's two realms, but the one that is responsive is Alexee's statement. Alexee's statement, which was made for the purposes of treatment and diagnosis. That's the standard under Rule 504. And the reason here that it is, the doctor comes in and says, I'm sorry, there's police here. We found a dead baby in the bathroom. So this is the first time the doctor has spoken to Alexee, and she made it clear later in an interview, and her actions made it clear at the time, and this is the substantial evidence that the district court relied on, that she wasn't going to get treatment without police present. So this information, the doctor didn't know where the placenta was. Indeed, the placenta was never found. The doctor didn't know anything about the circumstances of the birth. So Alexee's statement confirming that birth is absolutely necessary for her ongoing diagnosis and treatment. The problem here is not, I think where we're a little bit stuck is we're imagining that the police could have come in and maybe the doctor could have said something different that wouldn't have triggered the physician-patient privilege. And I would say, no, the police should absolutely not have been in the patient care room, nor should Dr. Vasquez have instructed her entire ED staff not to interact with Ms. Trevizo except for in the presence of law enforcement. She effectively conditioned her ongoing treatment on their presence.
So talk to me then about waiver?
Okay, let's talk about waiver.
Yeah.
So here, the state is effectively saying, and this is how I understand it, that Alexee has waived her privilege by the presence of third parties. Well, all we need to do is look at the text of the rule. The rule, and instead of me paraphrasing it, I'll just read it because I think that would be probably better. The rule defines confidential communications, and then we can get to the exception, which is the mandatory reporting exception. But the rule defines confidential communication as a communication made privately, not intended for further disclosure, and then this is the operative language, except to other persons in furtherance of the purpose of the communication. Now that has a little bit of a loop-de-loop feel, because what does it mean in furtherance of the purpose of the communication? We know that from the first part of the rule, which says that the communications that are privileged are those in furtherance of diagnosis and treatment. We also have direct case law on point. that says, we look at State versus Roper. And granted, Roper was construing an earlier version of this rule that specifically said family members were exempted from the privilege, from waiver. But the current version of the rule actually broadens it. And it broadens it so that it reflects the reality of New Mexico, which is that no person is going to the emergency department by themselves. Every person has a support person, whether it's extended family, whether it's their mother. I mean, and this idea that she's 19 and therefore it doesn't matter, that's not reflected in the law. The law says that any person, it's not someone who's absolutely necessary for care. It's someone who's there in furtherance of that care.
But so the officers are in the room
The
and
officers
they are not in furtherance of her care.
I would argue, Your Honor.
Would that be a waiver? I mean, I think the state asserts that that's a waiver, like that she's cognizant of what's happening and makes a knowing decision. I don't care that they're here. I'm going to answer this question. It's not a question, this statement for purposes of furtherance of my care.
Right. I think in that idea, it kind of loops back on there's two things here. One, it loops back on the idea of Miranda, that a statement, any waiver needs to be voluntary. And so for the same reasons we would argue she didn't voluntarily waive any rights under Miranda, she didn't voluntarily waive any rights.
So, Ms. Faber, assuming for purposes of discussion, assuming that the statement by the doctor, we found a dead baby in the bathroom, was a violation of the physician-patient privilege in the context of everything that's going on, she never had a chance to waive.
Correct. Right.
There's no waiver.
Right. You can't waive a right that you've not been informed
And,
of.
and she had no, and by the way, a fact I think that you left out, and I don't think you meant to, on the custody, is that the officers were armed,
Absolutely.
visibly armed.
Absolutely, visibly armed. And if I could just add one more thing to speak to that, Justice Vigil, and also finish answering your question, Justice Bacon, they also fit into other persons because the reason is because of what the doctor said. That and the charge nurse verified it and said the exact same thing. No one's talking to Alexee, AKA no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care because she's not.
But how was the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were. And it wasn't about her treatment. It was about, you did this and you're going to be in trouble and all of those comments. And in fact, if I remember correctly, I think the police even at one point said, please stop. So how was the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom are her own reactive statements to what she's just learned. But in the course of Alexee's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock and see if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexee's interests, that does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about D4.
Let's talk about a statute that also exempts it, a statute by the legislature. We have, interestingly enough, this privilege exists in statute, seems a fair rule was generated out of common law, 32A45. And then let's talk about those two things because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. Take a separate factual scenario in which they ask a 25-year-old, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician-patient privilege or of their similar privilege under 32A 4-5.
Right. So I think there's a couple of things here. And one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused exclusively on 32A43, but there is also, for your honors, 2411.5, and that's reporting a suspicious death. 32A43, excuse me, is part of the Children's Code. And we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including you have to report it either to police or to CYFD. If it goes to police, police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute. The operable statute is instead 2411.5, which is reporting a suspicious death. There is no dispute here that doctors did not try to resuscitate this neonate, that they found the neonate cold, blue, very clearly deceased.
I don't disagree with that recitation, but there also is an OMI report, at least according to the briefing. Is this a question of fact?
I think that part probably is a question of fact, but what's not a question of fact, yes, the stillbirth versus live birth is absolutely a question of fact. But the issue of what people knew at the time, as far as a report, there was no OMI report at that time.
So it does triggering the suspicious death statute.
Correct. All they saw was a suspicious death. And so that requires one of two things, either a report to local law enforcement or OMI. And then it's up to those people to take on the investigation. But even if we are operating in the realm of 32, of the Children's Code 32A43 and 32A45, I would still argue, Your Honor, that any reporting is not prospective reporting. It's not an ongoing duty of some sort of ongoing duty of disclosure. That would de facto turn a doctor and any other mandatory reporter into an investigator by police.
The only thing the doctor was required to report was, we found a dead baby.
I would say that the doctor was required to report the basis of her reasonable suspicion for child abuse. So we found, that's what the statute says. And that's what happened. We don't know that the doctor did it. We think it was and obviously the nurse was the first one to have a conversation with the police. The report was made. Now it's up to them to take on their investigatory tools. It doesn't mean they have an ongoing open entry into her medical records. The other thing that I would point out for Your Honor, especially Chief Justice, I want to make sure I'm answering your question, is that the records referred to in the Children's Code, I would argue generally referring to the records of the abused child. It doesn't mean, well, now let's look at the suspect and prospectively and in an ongoing manner have access to their records. That's why we have other investigative tools. They could have gotten a search warrant for her DNA. They could have gotten they could have taken her clothes and conducted communications on those. They could have gotten other warrants for medical records. They could have subpoenaed things. They didn't do any of that. Instead, that very night, between them and the
Well,
hospital.
some of it is based, some of the duty to report child abuse is based on the mother's records, because the pregnant woman who her toxicology screen might report a basis for child abuse, her self-report or clinical observation. When it's, I think when it's a drug exposed baby. So there's some basis in the statute. We're not just looking at the child.
Correct, Justice Zamora. But what that portion of the statute also shows us is New Mexico's commitment to reproductive health care. And that what that section says is that mom's status as having used drugs is not an automatic showing of child abuse. So I think here, if we're reading it in total, but I still would urge Your Honors, I think that the morass of 32A43 is avoided entirely by realizing what doctors saw, what they perceived, what mandatory reporters perceived was a suspicious death. We're not in the realm of CYFD. That's just not where we are here.
We're in the realm of doctor-patient privilege.
Correct.
If the defendant would have said instead, same scene, and the defendant would have said, the doctor says we found a deceased individual in the trash can. And the defendant said, I killed that individual. Would that have been privileged?
Well, Your Honor, I would say under that hypothetical, no, the
Okay.
reason being that that statement would not be for the purposes of diagnosis and treatment.
Okay,
That's, yeah.
fair enough. So let's get to the statements that are suppressed and tell us how that falls. Basically, in essence, the defendant said, baby fell out of me. That, your view, is tied to direct medical treatment because of the hemorrhaging. Understand that?
Not only the hemorrhaging, but what she's describing, what Alexee is describing, what we hear from hospital personnel and what we hear from the state is that from the moment Ms. Trevizo got to the hospital, that she was lying. Well, what do they base that on? That she said that she was bleeding, that she was in 10 out of 10 pain and she wasn't pregnant. It is surprisingly common how many people don't know they're pregnant until well into that case. So that's what they're basing her lying on. But what it really shows, and
But the deliberate intent.
not only that, Justice, but also it shows an obstetric emergency. She was probably having a placental abruption. And so what her describing to the doctor what happened in the bathroom would have been extraordinarily important. It is extremely unusual for a woman to be able to go into a space and within an 18-minute period deliver a baby, deliver a placenta, and then walk unassisted back to her room. That demonstrates the amount of morphine that she probably had in her system at that point, because I think, just as a matter of common sense, that's not something you should really be able to do. She would have been, so the idea here is she was in the midst and continued because of the hemorrhaging in the midst of a placental abruption. The doctor did not know where the placenta was. Had any of that been retained in her uterus, she would have bled out and died. So the idea here that her job, she had nothing for medical purposes to say to the doctor is simply not the medical reality. They needed to have an open conversation to make sure she got the care that she needed.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege. Case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
I see.
And so I see, like, you all will be gone. There will be a new attorney involved, probably a public defender, and we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's just a related but far field question.
Yeah, I think that I appreciate the question, Your Honor, and I'm not going anywhere. I'll be there for trial to the extent that it happens. But that's just not the operative question for the court to think about trial strategy and so on. I would point the court to State versus Gutierrez, in which this court has decided that they take a different approach than the feds do, for example, on constitutional rights.
Most things.
On most things. And that approach is we vindicate her rights because they need to be vindicated. Not for deterrence, not for anything else. Her rights were violated. What we need to do here today is try to right that wrong. And then when we get to trial,
she decides to voluntarily use
Correct.
the information.
Correct.
No harm, no foul.
correct.
Okay.
Exactly, Your Honor.
Thank you.
I realize that I am running with only 38 seconds left to go. And so I just want to highlight for the court, and I want to make sure I answer all of your questions, but I want to highlight for the court the policy impact for New Mexico of this decision, that it really matters. The stakes here just reach far beyond Alexee. If the state's position is adopted, the message is clear. And that's in moments of crisis, patients can't trust what they say to medical staff will remain confidential. And that's going to chill patients, especially adolescents, especially our rural patients, especially our vulnerable patients. It will also destabilize the physician-patient relationship that forms the bedrock of our healthcare system. And the district court drew that line correctly. Miranda and Rule 504, the relevant medical ethics, mandatory reporting statutes being narrow, that's where the line lies. In this case, it was completely obliterated. So to erase those safeguards would not only reweigh the facts, we haven't talked about standard of review here, but would not only reweigh the facts, which is what the state's in court in encouraging this court to do, but it would also reshape emergency care so that vulnerable patients would be at risk. And I just want to end on one thought, Your Honors, and that's that this case isn't about whether hospitals can notify police of a suspected crime. They can. And in most cases, they must. It's about what happens after. It's about what happens after that notification. Doctors are caregivers. Police are the investigators. Our law keeps those roles distinct. And it's essential for New Mexico that we continue to keep those roles distinct. And I just want to thank Your Honors for your questions and also ask that you please affirm the district court's order on both grounds, privilege and Miranda. Thank
Okay,
you.
one moment. Let's see if we have any other questions. Senior, did you have? Okay, thank you, counsel.
Thank you.